George Stinney Jr. is the youngest American with a confirmed birth date to be sentenced to death and executed in the 20th century. The entire injustice took less than 3 months from when George Stinney Jr. was arrested to his execution in the electric chair, approximately 83 days later. So let's go through exactly what happened to George Stinney Jr. and how the state of South Carolina put a 90-pound child in an electric chair. On a spring afternoon in 1944, George Stinney Jr., 14 years old, and his little sister were grazing the family's cow near railroad tracks. The railroad tracks separated black and white families in Alcolu, South Carolina. 2 white girls stopped by to ask where they could find wildflowers called maypops. When George said he didn't know, the girls went on their way. That moment, that brief, forgettable exchange between children over flowers, is the only connection George Stinney Jr. ever had to what came next. Alcolu was a small, working-class mill town. White and black neighborhoods were separated by railroad tracks, which was common for small southern towns of the time. Stinney's father worked at the town's sawmill, and the family resided in company housing. George was a normal kid in a normal family doing normal things. But in the Jim Crow South of 1944, normal had very different weight depending on which side of those tracks you lived on. That evening, when both young girls failed to return home, a search party was sent to find them. George Stinney and his family joined the search party, and he mentioned to another searcher that he had seen the girls earlier in the day. The next morning, after a pastor's son discovered the bodies of both girls in a shallow ditch, George was arrested and charged with their murders. That is the entire basis for what happened next. Not fingerprints, not blood, not a weapon, not a witness. Just a 14-year-old child mentioning during a community search that he had seen the girls earlier that day. When Dr. Asbury Cecil Bozard examined the girls' bodies, there was no clear sign of a struggle, but both girls had met violent deaths involving multiple head injuries. The town of Alcolu was in shock. George was immediately arrested for the murders and subjected to hours of interrogation without his parents or an attorney. The sheriff later claimed that George confessed to the murders, though no written or signed statement was presented. Not a note, not a recording, nothing on paper. Just the word of a white sheriff against a 14-year-old black child who had been sitting alone in a room for hours. It is reported that the police offered him ice cream to coerce a confession out of the young Stinney, a child. They offered a child ice cream, and then they told the world he had confessed to murder. George's father was fired from his job, and his family was forced to flee amidst threats on their lives. On March 26, a mob attempted to lynch George, but he had already been moved to an out-of-town jail. Let that sit for a second. A lynch mob formed. While George was already in custody, while the legal process had already begun, and officials had to physically move him to another county to keep him alive long enough to be killed by the state. Stinney's parents did not see him again before the trial. He had no support during his 81-day confinement and trial. He was detained at a jail in Columbia, 50 miles from Alcolu, due to the risk of lynching. So here is where we are, a 14-year-old boy, separated from his family, locked up 50 miles away, accused of a double murder on the basis of no physical evidence. With only a verbal confession that was never written down, surrounded by strangers, in a state that had already tried to kill him before his trial even began. George's former cellmate, Wilford Hunter, issued a statement saying the little boy vehemently denied the charges. "I didn't do it." George innocently asked him, "Why would they kill me for something I didn't do?" The entire proceeding against George Stinney, including jury selection, took place on April 24, 1944. 1 day, start to finish. Arrested, tried, convicted, and sentenced to death, all within the span of a single morning in a segregated South Carolina courthouse. What happened inside that courthouse defies every standard of justice, even by the limited standards of 1944. George Stinney Jr. stood trial inside the Clarendon County Courthouse, where a statue of a Confederate soldier towered out front. Among those who had been barred from the courtroom for being black were George's siblings, Amy, age 8, Clarence, 12, and Kathleen, 10. His own family could not walk through the door. They had all been with George on the day of the killings and might have testified in his defense. But George's attorney, Charles Plowden, who would go on to be elected to the state legislature, had never even interviewed his siblings. Think about what that means. The very people who could have placed George at home, who could have destroyed the entire basis of the prosecution, were never even contacted by the man paid to defend him, not once. Stinney's court-appointed counsel was Charles Plowden. a tax commissioner campaigning for election to local office. This was not a defense attorney. This was a politician who needed the votes of the same white community that was baying for George's blood. The conflict of interest was not subtle. It was not hidden. It was baked into the structure of the defense from the very first moment. During the 2-hour trial, Plowden failed to call witnesses to the stand or present any evidence that would cast doubt on the prosecution's case. The most significant piece of evidence presented against Stinney was his alleged confession, but there was no written record of the teenager admitting to the murders. The prosecution's entire case was the sheriff walking into a courtroom and telling an all-white jury what he claimed a terrified black child had said in a locked room with no one else present. That was it. That was the totality of the evidence. More than 1,000 white Americans crowded the courtroom, but no black Americans were allowed. As was typical at the time, Stinney was tried before an all-white jury. In 1944, most African Americans in the South were disenfranchised and therefore not present on the rolls of those available to serve on juries. By the time of his trial, Stinney hadn't seen his parents in weeks, and they were too afraid of getting attacked by a white mob to come to the courthouse. So the 14-year-old was surrounded by strangers, up to 1,500 of them. Every single face in that courtroom was white. The judge was white, the jury was white, his lawyer was white, the prosecutor was white. The sheriff who claimed he confessed was white. George sat alone in the middle of all of it. Judge Philip H. Stoll sentenced Stinney to death by electrocution. 10 minutes for a capital case. For a child's life. There is no transcript of the trial, and no appeal was filed by Stinney's counsel. The attorney who never interviewed witnesses, never presented evidence, and never challenged the prosecution's non-existent case, also never filed a single appeal. Not one. George Stinney Jr. walked back to a jail cell and waited to die. George Stinney Jr.'s execution was not without protest. Meanwhile, hundreds of letters and telegrams poured into the governor's office, begging him to show mercy to Stinney. Stinney's supporters appealed with everything from the basic idea of fairness to the concept of Christian justice. But in the end, none of it was enough to save George Stinney. Despite appeals from black advocacy groups, Governor Olin Johnston refused to intervene. The governor looked at a 90-pound child with no physical evidence against him. No effective lawyer, no appeal, no transcript, and a confession that existed only in a sheriff's testimony, and he signed the death warrant anyway. At 7:30 a.m. on June 16, 1944, inmate number 260, dressed in a loose-fitting striped jumpsuit, was escorted to the little brick death house at the state penitentiary in Columbia. A Bible tucked under his arm. He was 14 years old. He weighed 90 pounds. He carried a Bible because it was the only thing in the world he still had. On June 16, 1944, George Stinney Jr. walked into the execution chamber at the South Carolina State Penitentiary in Columbia with a Bible tucked under his arm. Weighing in at just 95 pounds, he was dressed in a loose-fitting striped jumpsuit, strapped into an adult-size electric chair. He was so small that the state electrician struggled to adjust an electrode to his right leg. The adult-sized electric chair was built for grown men. George Stinney Jr. was not a grown man. He was a child, and the machinery of state death had not been designed with children in mind. Not because they didn't execute children, but because no one thought it necessary to modify the equipment. At 90 pounds, he was so small that state officials made him sit on a book, said to be the Bible he carried with him to the death chamber in order to strap him to the electric chair. The Bible he walked in with became the booster seat they sat him on to kill him. An officer asked Stinney if he had any last words to say before the execution took place, but he only shook his head and said, "No, sir, no last words. No declaration of innocence for the record. No dramatic final statement. Just a child, shaking his head, telling an adult, 'No, sir,' the way children are taught to speak to adults." According to witnesses of the execution, the initial electric charge caused Stinney's mask to fall off, exposing the pure agony on his face as tears rolled down. Other accounts add that saliva emanated from his mouth. Purportedly, the first jolt did not kill him, and the executioner had to try twice before George Stinney Jr. was pronounced dead. When Stinney's emaciated form was hit with the 2,400 volts of electricity, his body jolted forward and the face mask slipped off, revealing a wide-eyed and tearful face. The state of South Carolina killed George Stinney Jr. at 7:30 in the morning. It took 2 attempts, and when it was over, Stinney was buried in an unmarked grave at the Calvary Baptist Church Cemetery in Lee County, South Carolina. No marker, no name, as if the goal from the very beginning had been erasure. To make George Stinney Jr. disappear so completely that the question of what was actually done to him would never have to be answered. George Stinney remains the youngest person executed in the U.S. in the 20th century. The execution of George Stinney Jr. was not an isolated event with a beginning and an end. George's father was fired from his job at the sawmill that night. Amid threats of a white mob, the family was forced to flee town. They lost their home, which was company housing, the same night their son was taken. They lost their income. They lost their community. And then 81 days later, they lost George. Following Stinney's arrest, his father was fired from his job at the local sawmill, and the Stinney family had to immediately vacate their company housing. The family feared for their safety. Stinney's parents did not see him again before the trial. His mother and father never saw their son again after the night the deputies came to the door. They were not in the courtroom. They were not allowed. They were not at the execution. They could not even bury him properly. Just an unmarked grave in a cemetery. While the rest of the world moved on, I wish that I could have come forward much sooner. Charles Stinney, George's brother, said, "George's conviction and execution were something that my family believed could happen to any of us. Therefore, we made a decision for the safety of the family to leave it be. He and his siblings all eventually moved north. That is the weight of it. Not just the grief. The fear that drove that grief underground for decades. The understanding that speaking up, even to say my brother was innocent, could get you killed. So they stayed quiet. They moved away. They carried it." George's sister, Aim Ruffner, repeated the same story she had told since 1944. Noting that she remembered the day well because no white people came around to the black side of town. "Somebody followed those girls and killed them," she told the court. Aim had been standing right next to George when the girls stopped to ask about the flowers. She was his alibi. She was a child herself, 7 years old, and for 70 years that alibi sat in her memory, never entered into a court record, never tested by cross-examination, never heard by a jury, because no one in 1944 thought to ask her. People in the Alcolu community had not been comfortable talking about the Stinney case. A pastor who served the local black church for 23 years pointed out that people were reluctant or afraid to speak. If you questioned anybody, they were very tight about the story. He added, "I never try to push them, because I felt that there was fear, that if you talked too much, the wrong people would get the message." An entire community, decades of silence, not because people didn't know what had happened, but because speaking the truth out loud was dangerous. The execution of George Stinney Jr. did exactly what it was designed to do in a Jim Crow town. It put fear into people and kept them quiet, and for 60 years it worked. At the 2014 hearing, Amy Stinney Ruffner, 77, said she had been with her brother. When the two girls stopped to ask about Maypops, Kathleen Stinney Robinson, 79, and Charles Stinney, 78, in frail health and testifying via video, said George was home all the rest of that afternoon. 3 elderly siblings testifying to what they had known since 1944. Since the day the deputies came and took their brother away, they had waited 70 years to be heard, in poor health, giving testimony over a video screen because they were too frail to appear in person. Catherine Robinson, one of Stinney's sisters, said that when we got the news, we were sitting with friends. I threw my hands up and said, "Thank you, Jesus." Someone had to be listening. It's what we wanted for all these years. She said that despite the many years between her brother's execution and exoneration, she has great memories of the time they spent together. For decades after June 16, 1944, the case of George Stinney Jr. was not taught in schools, not revisited in court, not even spoken about openly in Alcolu. It lived only in the silence of a community that had learned what happened when it spoke. It was not until 2004 that George Frierson, a local historian who grew up in Alcolu, started researching the case after reading a newspaper article about it. Frierson's work marked the beginning of a slow turning, a crack in 6 decades of silence that eventually became a flood. In October 2013, attorneys for the Stinney family filed a petition asking the court to overturn the guilty verdict. Just 3 months later, Sumter County Circuit Judge Carmen Mullen held a 2-day evidentiary hearing to determine whether George Stinney had received a fair trial. The state of South Carolina, the same state that had arrested, tried, convicted, sentenced, and executed George Stinney. In 83 days, now sent its own prosecutor to argue that the conviction should stand. The state argued at the hearing that, despite all the unfairness in this case, George's conviction should stand. They weren't trying to railroad every black person associated with Alcolu and these little girls. The defense pushed back hard. The state, as an entity, has very unclean hands, Attorney Miller Sheely argued. During the trial, psychologist Dr. Amanda Solis, a defense witness, said Stinney likely confessed because of the power differential between his position as a 14-year-old black male being questioned by white, uniformed law enforcement in a small segregated town, and then Judge Carmen Mullen issued her ruling, one that dismantled the 1944 proceedings piece by piece. In her ruling, Mullen said she found fundamental constitutional violations of due process. In the 1944 prosecution of the teen, I don't have a murder weapon. I don't have bloody clothes. I don't have a written confession, Mullen said. I have nothing. We don't know whether or not he did it, but that wasn't the issue. It was whether or not his constitutional rights were preserved, and they weren't, and that was clear. And the more I got into it, the more I saw how obvious and blatant it was, that he wasn't afforded his constitutional protections. Methods employed by law enforcement in their questioning of the defendant may have been unduly suggestive, unrestrained, and non-compliant with the standards of criminal procedure, as required by the 5th and 14th Amendments. Mullen wrote, "We know that law enforcement separated the defendant from his parents, and otherwise took advantage of his age and stature to garner a result they determined to be true and just. One of the most shocking things in the George Stinney case is that he was tried by a jury of 12 white men." Mullen said, "That certainly is not a jury of his peers, and that certainly was not a cross-section of Clarendon County at the time, which was half African American, half white, and his family was not even allowed in the courthouse." The trial court disagreed with the state and vacated the conviction, finding that George Stinney was fundamentally deprived of due process throughout the proceedings against him, that the alleged confession simply cannot be said to be known and voluntary, that the court-appointed attorney did little to nothing to defend George, and that his representation was the essence of being ineffective. The judge concluded, "I can think of no greater injustice." Mullen's ruling was a rare application of coram nobis, which is used to correct errors of due process when all other legal options have been exhausted. It was not a pardon, and the family was clear about why that mattered. "A pardon is forgiving someone for something they did," said Norma Robinson, Stinney's niece. "That wasn't an option for my mother, my aunt, or my uncle. We weren't asking forgiveness. What the family wanted, what 70 years of silence had been building toward, was the law itself saying, this was wrong. We killed an innocent child." And on December 17, 2014, that is exactly what happened. Children who were sentenced to death, and those who were executed in the U.S., were overwhelmingly poor, black, male, and residing in southern states. Legal scholar Victor L. Stribe's landmark 1987 study of American juvenile executions found that in a nation where black people have never comprised more than 15% of the population, 69% of people executed for crimes committed before they turned 18 were black. George Stinney Jr. was not an anomaly. He was a data point in a pattern that stretched across centuries, a pattern that the United States Supreme Court finally confronted in 2005. The U.S. tolerated the execution of children until 2005, when the Supreme Court issued its landmark Roper v. Simmons decision, banning the juvenile death penalty as a violation of the Eighth Amendment's prohibition against cruel and unusual punishment. The ruling came too late for the 281 people executed in America for crimes that occurred when they were children. And what the Stinney case forces us to reckon with, even now, is not simply the horror of one execution. It is the horror of a system that moved fast and deliberately and never looked back. From the moment a search party mentioned George's name to the moment they flipped that switch, 83 days passed. Accused of murdering 2 white girls without a shred of physical evidence, George Stinney Jr. was charged, tried, convicted, and executed in a span of just 83 days. Some people in Alcolu today still believe George was guilty. Jimmy Hodge, who was 12 when his father joined the search party, still believes Stinney is guilty and doesn't accept the new information that lawyers brought to light. After 70 years, I don't know where it all came from. Why is it just showing up now? That question, why is it just showing up now, is its own answer. It took 70 years because for 70 years, the people who knew the truth were too afraid to say it out loud. I'm happy for this day because it's been such a long time coming. But then I cringe when I go back into that childhood and think of George back in the day. Catherine Robinson said he had no one to help him. I get chills every time I think about it. George Stinney Jr. was 14 years old. He weighed 90 pounds. He walked into a death chamber carrying a Bible. He said no, sir, when they asked if he had any last words. And then the state of South Carolina killed him twice because the first jolt wasn't enough and buried him in an unmarked grave. What makes this the scariest child execution in American history is not just the execution itself. It is everything that made it possible. The speed, the silence, the system, and the 70 years it took for anyone with the power to act to simply say, "This was wrong."